professional responsibility, rule statements. Beginning with Rule 2.1. 2.1 Advisor. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Next rule, Rule 1.6, Duty of Confidentiality. A lawyer shall not reveal information related to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or disclosure is permitted by paragraph B. B. A lawyer may reveal information relating to the representation of a client to the extent that the lawyer reasonably believes: 1. To prevent reasonable certainty of harm, death, or substantial bodily harm. 2. To prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests or property of another, in furtherance of which the client has used or is used the lawyer's service. 3. To prevent, mitigating, or rectifying substantial injury to the financial interests or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. 4. To secure legal advice about the lawyer's compliance with the rules, to seek outside counsel if you are in compliance with professional rules. 5. To establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to establish a defense to a criminal charge or civil claim against the lawyer based upon conduct which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation by the client. Basically, if you get sued by a client for malpractice, then they've implicitly waived the attorney-client privilege. 6. To comply with other law or court order. Or 7. To detect and resolve conflict of interest arising from the lawyer's change of employment or from change in the composition or ownership of a firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. C. A lawyer shall make all reasonable efforts to prevent the individual or the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Comment 4. Paragraph A prohibits a lawyer from revealing information relating to the representation of a client. Then it goes on to say, a lawyer's use of a hypothetical to discuss issues related to the representation is permissible so long as there is no reasonable likelihood that the listener will be able to ascertain the identity of the client or situation involved. 6. Disclosure adverse to advice. This is dealing with B1, the death or bodily harm exception. Paragraph B1 recognizes the overriding value of life and physical integrity and permits disclosure reasonably necessary to prevent reasonably certain death or substantially bodily harm. Comment 16. Paragraph B permits disclosure only necessary to the extent the lawyer reasonably believes the disclosure is necessary to accomplish one of the specified purposes. All right. Moving on to Rule 8.4, professional misconduct. 8.4, professional misconduct. It is professional misconduct for a lawyer to A. Violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or to do so through the acts of another. B. Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. C. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. D. Engage in conduct that is prejudicial to the administration of justice. E. State or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law. Or F. Knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of judicial conduct or other law. G. Engage in conduct that the lawyer knows or reasonably knows is harassment, discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status, and conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, withdraw from representation in accordance with Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. I don't see any comments. Okay, so Rule 8.1. maintaining bar admission and disciplinary matters. An applicant for admission to the bar or a lawyer in connection with the bar admission application or in connection with a disciplinary matter shall not A. knowingly make a false statement of material fact, or B. fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by Rule 1.6. Rule 5.1. So just a quick overview for the next few rules. 5.1 deals with managers and partners in a law firm. 5.2 deals with rules for subordinates, and Rule 5.3 deals for non-lawyers like paralegals, secretaries, things like that. And then 5.5, a little less related, deals to multi-jurisdictional practice of law. So Rule 5.1. Responsibilities of partners, managers, and supervisory lawyers. A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. B. A lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. C. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if 1. The lawyer orders or with knowledge of the specific conduct ratifies the conduct of that lawyer involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the other lawyer practices or has direct supervisory authority over the other lawyers and knows of the conduct at the time when the consequences can be avoided or mitigated but fails to take reasonable remedial action. 5.1 does not highlight any comments, so we'll move on to Rule 5.2, responsibilities of a subordinate lawyer. A lawyer is bound by the rules of professional conduct notwithstanding that the lawyer acted at the direction of another person. B, a subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. No comments highlighted. So moving on to 5.3, responsibilities regarding non-lawyer assistance. With respect to a non-lawyer employed or retained by or associated with a lawyer, A partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligation of the lawyer. B, a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And C, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if 1. The lawyer orders or, with the knowledge of specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm, or has direct supervisory authority over the person and knows of the conduct at the time in which its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Comment 2 here says, for non-lawyers within the firm, lawyers generally employ assistants in their practice, including secretaries, investigators, law student interns, paraprofessionals. It's just highlighting who might be a non-lawyer. That's a non-lawyer within the firm. Non-lawyers outside the firm, so a lawyer may use non-lawyers outside the firm to assist a lawyer in rendering legal services to a client. Nothing of note there. Moving on to Rule 5.5, unauthorized practice of law, multi-jurisdictional practice of law. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. B, a lawyer who is not admitted to practice in this jurisdiction shall not, 1, except as authorized by these rules or other law, establish an office or other systemic or continuous presence in this jurisdiction for the practice of law, or 2, hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. C, a lawyer admitted in another U.S. jurisdiction and not disbarred or suspended from the practice of law in any jurisdiction may provide legal services on a temporary basis in this jurisdiction, provided that 1. they are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who is actively participating in the matter. 2, are in reasonably related or a pending potential proceeding before a tribunal in this or another jurisdiction if the lawyer or the person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. 3, are reasonably related to the pending potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction, if the services arise out of or are reasonably related to the lawyer's practice in the jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hoc vice admission, or 4, are not within paragraph C2 or C3 that arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. D, a lawyer admitted in another U.S. jurisdiction or in a foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof, or a person otherwise practicing as an in-house counsel under the laws of a foreign jurisdiction may provide legal services through an office or other systemic continuous presence in this jurisdiction. So that's if you're practicing in-house, you can practice in that jurisdiction where you're not licensed. That one, so long as one, they are provided to the lawyer's employer or its organizational affiliates, are not services for which the forum requires pro hoc vice admission, and when performed by a foreign lawyer and requires advice on the law of this or another jurisdiction of the United States, such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice. Or 2, are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction. E, for the purposes of paragraph D, 1, the foreign lawyer must be a member in good standing of a recognized legal profession in a foreign jurisdiction, the members of which are admitted to practice as lawyers or counselors at law or the equivalent and subject to effective regulation and discipline by a duly constituted professional body or public authority. Or 2, the person otherwise lawfully practicing as an in-house counsel under the laws of a foreign jurisdiction must be authorized to practice under this rule by, in the exercise of its discretion, the highest court of the jurisdiction. Rule 1.8, settling malpractice claims. Oh, real quick, going back to 5.5, comment 14, paragraph C3 and C4, that's practicing in another jurisdiction. A variety of factors evidence such a relationship, that it's related to a matter in the home state, right? The client's lawyers may have been previously represented by the lawyer or may be resident in or have substantial context with the jurisdiction in which the lawyer is admitted. All right, so going back to Rule 1.8. All right, Rule 1.8. This is a long rule. The part that we focus on relates to settling malpractice claims. In 1.8H, a lawyer shall not, this is before the fact, 1, make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or 2, after the fact, a lawyer shall not settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. So before the fact, you want to prospectively limit your liability, you need to give the other side an opportunity to get independent representation to make the agreement. If you want to settle a claim after the fact, you need to tell them in writing of the desirability of seeking and giving a reasonable opportunity to obtain independent counsel. And that's Rule 1.8. Going ahead to Rule 6.2. Appointment by court and exceptions. So 6.2 begins with a rule and then gives 3 exceptions. 6.2, Accepting appointments. A lawyer shall not seek to avoid appointments by a tribunal to represent a person except for good cause, such as A. Representing the client is likely to result in violation of the rules of professional conduct or other law. B. Representing the client is likely to result in unreasonable financial burden on the lawyer. Professor Kordick says, for example, if you're a solo practitioner, and this is a very time-consuming, all-consuming, several-year-long case, and the payout is uncertain, might financially ruin you. That might be an example of financial burden that you might seek to avoid appointment. Or C, the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. Comment 1 that says a lawyer ordinarily is not obligated to accept a client whose character or cause the lawyer regards as repugnant. The lawyer's freedom to select clients is, however, qualified. All lawyers have a responsibility to assist in providing pro bono publico service. See Rule 6.1 for that. An individual lawyer fulfills this responsibility by accepting a fair share of unpopular matters or indignant or unpopular clients. A lawyer may also be subject to appointments by a court to serve unpopular clients or persons unable to afford legal services. That's 6.2. Moving on to Rule 1.16, a reason to withdraw. So Rule 1.16, declining or terminating representation. Except as stated in paragraph C, a lawyer shall not represent a client, or where representation is commenced, shall withdraw from the representation of a client if 1. The representation will result in a violation of the rules of professional conduct or other law. 2. The lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or 3. The lawyer is discharged, fired by the client. That is the shalls. 1.6b mays. Except as stated in paragraph C, a lawyer may withdraw from representing a client if the withdrawal can be accomplished without material adverse effects in the interest of the client. That's 1. 2. The client persists in course of action involving the lawyer's services and the lawyer reasonably believes is criminal or fraudulent. 3. The client has used the lawyer's services to perpetuate crime or fraud. 4. The client insists upon taking action the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. 5. The client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. 6. The representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client. Or 7. Other good cause for the withdrawal exists. C. The lawyer must comply with the applicable law requiring notice or permission of a tribunal when terminating a representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for termination of the representation. D. Upon termination of the representation, a lawyer shall take steps to extend reasonably practical to protect the client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, and refunding any advance payments or fees or expenses that had not been earned or incurred. The lawyer may return papers relating to the client to the extent permitted by other law. 1.5 Fees. A lawyer shall not make an agreement for charge or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following. 1. The time and labor required, the novelty and difficulty of the question involved, the skill requisite to perform the legal services properly. 2. The likelihood, if apparent to the client, that the acceptance of a particular employment will preclude other employment by the lawyer. 3. The fee customarily charged in the locality for a similar legal service. 4. The amount involved in the results obtained. 5. The time limitations imposed by the client or the circumstances. 6. The nature and length of the professional relationship with the client. 7. The experience, reputation, and ability of the lawyer or lawyers performing the services. And 8. Whether the fee is fixed or contingent. B. The scope of the representation and the basis or rate of the fee and expenses for which the client will be reasonably or responsible shall be communicated to the client, preferably in writing, but not required, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fees or expenses shall also be communicated to the client. C. A fee may be contingent upon the outcome in the matter for which the services are rendered, except in a matter in which a contingent fee prohibited by paragraph D or other law. A contingent fee arrangement shall be in a writing signed by the client. Contingent fees shall be in writing signed by the client. Contingent fees shall be in writing signed by the client. Remember that. And shall state the method for which the fee is to be determined, including percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation, and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after contingent fee is calculated. The agreement must clearly notify the client of any expenses for which the client will be liable, whether or not client is the prevailing party. Upon conclusion of the contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome in the matter, and if there is recovery, showing the remittance to the client and the method of its determination. D. A lawyer shall not enter into an arrangement for charge or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon the securing a divorce, upon the amount of alimony or support or property settlement in lieu thereof. Or 2. A contingent fee for representing a defendant in a criminal case. So you can't do it to get a divorce, can't do it as a percentage of alimony or support that you get, and you can't do it as a criminal defendant lawyer. You can't do contingent fees for those. E. A division of a fee between lawyers who are not in the same firm may be made only if 1. The division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. 2. The client agrees to the arrangement, including the share the lawyers will receive, and the agreement is confirmed in writing. And 3. The fee is reasonable. That's 1.5. Back to 1.2. Essentially means the client makes the decisions and the lawyer executes those decisions. 1.2. Scope of representation and allocation of authority between client and lawyer. A. Subject to paragraph C and D, lawyers shall abide by a client's decision concerning the objectives of representation and, as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as is implicitly authorized to carry out in the representation. A lawyer shall abide by a client's decision whether to settle a matter. So the client decides whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. That was starred A. So criminal case, the criminal defendant decides whether to waive a jury trial, how to plead, whether to testify. B. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, moral views or activities. C. A lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. So a lawyer can limit the scope of the representation in writing. D. This one is starred. A lawyer shall not counsel a client to engage in or assist a client in conduct that the lawyer knows is criminal or fraudulent, but the lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of a law. So you're allowed to say, you're allowed to tell your clients what the consequences of their actions are. You're allowed to figure out what the scope of the law is, how far you can push the law, as long as it's good faith effort. But we did go through a hypo class where if you maybe said to your client's like, I'm gonna rob a bank, well, I don't know, I'm thinking about robbing a bank, and the lawyer says, well, it is less penalty for robbing a state bank rather than a federal bank. Yes, you're just telling your client the law, but all the circumstances around that, you are kind of advising your client on the best way to break the law, on the most advantageous way to break the law. So that there might run afoul of advising your client to break the law. But in general, just in a vacuum, you can tell your client just the consequences of their actions, the scope of the law, things like that. So next, we move on to our last part. 1.7 concurrent conflicts of interest, 1.9 former conflicts, and 1.10 imputed conflicts of interest. So starting with 1.7, that is conflict of interest for current clients. A, Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person by non-personal interest of the lawyer. Professor Kordick makes a point in class to say that A2 conflicts are almost always a subset of A1 conflicts, so it is possible to have both an A1 and A2 conflict. B. Notwithstanding the existence of a concurrent conflict of interest under paragraph A lawyer may represent a client if all of these 4 things happen. So 1 through 3 are going to be examples of just like non-waivable conflicts because you'll fail this test under B. But if you pass all of these and you get it in writing, as you'll see, that can be a waivable conflict of interest. So the first non-waivable conflict, B1, a lawyer reasonably believes that the lawyer will not be able to provide competent and diligent representation to each affected client. The reasonably believes is an objective test from the lawyer's perspective. That's going to be addressed in comment 15. We'll get back to that later. A lawyer reasonably believes the lawyer will be able to provide competent and diligent representation to each affected client. That's when you can represent. Okay. 2, the second step, the representation is not prohibited by law. That's comment 16. 3, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. So you can't represent both sides of the V, basically. And 4, each affected client gives informed consent confirmed in writing. Okay. So you can represent them all if lawyer, from their perspective, reasonably believes the lawyer will be able to provide competent, diligent representation. 2, representation is not prohibited by law. 3, representation does not involve the assertion of a claim by one client against another client, basically opposite sides of the V. And 4, each client affected, all the clients affected give their informed consent confirmed in writing. So B1, lawyer reasonably believing the lawyer will be able to provide competent services. That's addressed in comment 15. In class, we talk about that and say, under paragraph B1, representation is prohibited if in the circumstances the lawyer cannot reasonably conclude that the lawyer will be able to provide competent and diligent representation. Makes sense, easy enough. For B2, the representation is not prohibited by law. That points us to comment 16. Paragraph B2 describes conflicts that are non-consentable because the representation is prohibited by law. For example, in some states, substantive law provides that the same lawyer may not represent more than one defendant in a capital case. Makes sense. Even with the consent of the clients, and under federal criminal statutes, certain representations by a former government lawyer are prohibited despite the informed consent of the former client, the government. In addition, decisional law in some states limit to the ability of a governmental client, such as the municipality, to consent to conflicts of interest. Okay. He also points us to informed consent in comment 18 and 19. In 18, informed consent requires that each affected client, not just the new one, not just the old one, both affected clients be aware of the relevant circumstances of the material and reasonably foreseeable ways that the conflict could have adverse effects on the interests of the client. The information required depends on the nature of the claim, the conflict, and the risks involved. Makes sense. Comment 19. Under some circumstances, it may be impossible to make a disclosure necessary to obtain consent. For example, when the lawyer represents different clients in related matters, and one of the clients refuses to consent to the disclosure necessary to permit the other client to make an informed decision. The lawyer cannot properly ask the latter to consent. Makes sense. That's 1.7, concurrent conflicts of interest. Now we're moving on to 1.9, conflicts among former clients. Comments among former clients. A lawyer who has formerly represented a client, this is paragraph A, formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of a former client unless the former client gives informed consent confirmed in writing. You have to get it from the former client confirmed in writing in 1.9. Lawyers shall not knowingly represent a person, this is B. A lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client. One, whose interests are materially adverse to that person, and two, about whom the lawyer had acquired information protected by Rules 1.6 and 1.9c is material to the matter, unless the former client gives informed consent confirmed in writing. And then C, a lawyer who has formerly represented a client in a matter or whose present or former firm has formerly represented a client in a matter shall not thereafter, one, use information related to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to the client, or when the information has become generally known, or two, reveal information related to the representation except as these rules would permit or require with respect to the client. Moving on to our last rule, Rule 10, imputed conflicts. Imputed conflicts. A, while lawyers are associated with a firm, none of them shall knowingly represent a client when any one of them practices alone would be prohibited from doing so by Rule 1.9 or 1.7 unless the prohibition is based on a personal interest of the disqualified lawyer and does not present a significant risk of material limiting the representation of the client by the remaining lawyers in the firm. Or B, the prohibition is based on Rule 1.9a or B, that's the former clients, and arises out of the disqualified lawyer's association with a prior firm, and the disqualified lawyer is timely screened from the participation in the matter. It is partitioned and is taken no fee from the matter. Two, written notice is promptly given to any affected former client to enable the former client to ascertain compliance with the provisions of this rule, which shall include the description of the screening procedures employed, statement of the firm and the screen lawyer's compliance with these rules, a statement that review may be available before a tribunal, and an agreement by the firm to respond promptly to any written inquiries or objections by the former client about the screening procedures, and three, certifications of compliance with the rules and with the screening procedures are provided to the former client with the screen lawyer by the partitioner of the firm at reasonable intervals upon the former client's written request and upon termination of the screening procedures. B, when a lawyer has terminated an association with a firm, the firm is not prohibited from thereafter representing a person with interests materially adverse to those of a client represented by a formerly associated lawyer and not currently represented by a firm, unless one, the matter is the same or substantially related to that in which the former associated lawyer represents the client, and two, any lawyer remaining in the firm has information protected by 1.6, 1.9 that is material to the matter. C, a disqualification prescribed by this rule may be waived by the affected client under the conditions stated 1.7, I think that's written consent, or informed written consent. D, the disqualification of lawyers associated in any firm with former or current government lawyers governed by Rule 1.11. We don't talk about that in class, though.